Rocks falling off a hillside onto a road or highway, well, it's been known to happen. And when they hit vehicles such as cars or trucks, they can cause damage and injury. But what happens if damage or injury is caused by a rock thrown by somebody? Different standard? Well, that's what we explore on today's video blog as we talk about, again, a real case involving real people. Involves a truck driver coming down a freeway in Northern California. He was in a truck that unfortunately was struck by a piece of concrete thrown by a 15-year-old kid who was on an overpass. The kid threw the concrete directly onto the truck below. It smashed through the window and caused brain damage to the driver. Very badly injured. Well, the kid was prosecuted for assault with a dangerous weapon, deadly weapon, and the truck driver, needless to say, went through an awful lot of hassles with regard to hospitalization and lost income and all kinds of issues, continuing ongoing problems. And he, through his attorneys, brought claim against the kid, of course, who didn't have any real money, but then also brought claim against the manufacturer of the truck he was in. And what they said was that the truck should have had a windshield that was sufficiently strong that it did not break when a rock came through it. It was established the rock weighed approximately 2.5 pounds, not particularly heavy, but again, when it's dropping off an overpass, it gets to start to develop some velocity and can pack a wallop. Well, at trial, the manufacturer of the truck argued, hey, we are not at fault because we can't anticipate criminal activity. Here was a criminal action that caused this injury. We're not at fault for criminal activity. And therefore, if you're going to impose upon us a standard for design of vehicles, you got to consider whether we should be on notice of a heightened level of foreseeability that we should anticipate all kinds of criminal action, and only then, if you find, the jury, that we should expect all kinds of criminal activity, only then can you find us at fault. Well, on the other side, the plaintiff said, you know, this is a rock. Rocks have been known to hit windshields. We contend that the windshield was not strong enough. But what the judge did is he sided with the defendants. And he said, jury, you have to find, in this instance, that there was a reasonable basis for the truck manufacturer to anticipate criminal activity of this nature. Okay, well, the jury found that it wasn't reasonable for the truck to anticipate that kind of criminal activity, and they found in favor of the truck manufacturers. Case went up on appeal, and at the 3rd District Court of Appeals in the state of California, the judges looked at it and said, you know what? A rock is a rock. It doesn't make any difference whether it is coming off the side of a hill, whether it's coming off a piece of construction equipment that's going down the highway next to another vehicle, or whether it's thrown by a 15-year-old kid off of an overpass. A 2.5-pound rock is a 2.5-pound rock. And therefore, the question is whether or not the design of the vehicle should have anticipated being hit by a 2.5-pound rock. It should not have come into evidence or have really been considered that that rock was thrown by someone who was convicted of a criminal act. The fact is, it was a 2.5-pound rock, and that's what it was, and we only have to consider, the jury only has to consider whether the trucking company should have designed their vehicle, when I say trucking company, the trucking manufacturer should have designed their vehicle to withstand that kind of impact. So the appellate court said back on down to the trial court where the case would be tried again. So what do we learn from this case? Well, we learn an important thing, and that is sometimes injury can occur, and not infrequently, as a result of criminal activity. But many times there are circumstances in which that criminal activity could have been foreseen, and many times that criminal activity is really no different than regular circumstances that could be encountered anytime, any place. And if that's the case, well, the way in which that particular fact is going to be viewed is different. Because if it's a kind of thing, such as the throwing of a rock, that could have occurred as a result of any number of other causes, they say coming off a hillside, coming off a construction vehicle, well then that's the standard that should apply. And the jury should not consider the fact that it actually was criminal activity that gave rise to the fact the rock was thrown. And that's how the rock hit the windshield. All right, well, we bring you this case as we bring you cases every week, so you understand how the law really works. I'm David Allen.